Hello students, so let's cover complete polity and governance of July month in this video. So the first topic is Uniform Civil Code. So the Uniform Civil Code is in news because 22nd Law Commission is taking various suggestions from different people to implement on Uniform Civil Code. Okay, so about this various suggestions are coming from different stakeholders. So the 22nd Law Commission was formed in 2020. So its tenure is 3 years. The chairman of 22nd Law Commission is Justice Rituraj Avasthi. So generally Law Commission will be formed to do research on the present laws, and if there is any need then they recommend to reform the laws. So recently in June month it has released 279th report. So in that report the Law Commission has recommended to retain the sedition law, and now it is taking suggestions from various stakeholders on the Uniform Civil Code. So generally Uniform Civil Code is mentioned under the Article 44 of Directive Principles of State Policy in our Constitution. The next topic is judicial pendency. So there are present 5.02 crore cases pending in India. So the pending cases in judiciary is called judicial pendency. So recently Ministry of Law and Justice informed that Rajya Sabha that there are around 5.02 crore cases pending. So the reasons for the pendency of cases is the delay in filling up the vacancies of judicial officers and judges. There is a lack of infrastructure due to lack of funds. There is a delayed investigation, and there are many issues like abusing the contempt of court power, improper courtroom behavior, etc. So due to all these reasons the court cases are not solved, and it has been going on increasing the cases. So this is about judicial pendency. And coming to the data, at present there are only 21 judges for every million people, whereas the Law Commission has recommended 50 judges. Actually we should have 50 judges per million population, but we have only 21 judges, which is less than half of the recommendation members. Okay, and the budgetary allocation is very less. So due to this less budgetary allocation, the infrastructure is not up to date. So there is around 0.08 to 0.09% of GDP allocation to the judiciary. The next topic is Directorate of Enforcement or Enforcement Directorate. So ED generally investigates on economic crimes and the violation of foreign exchange laws. So it deals mainly with the financial aspects of the country. So at the international financial frauds or the international smuggling which is related to money laundering, all these things come under the acts of Enforcement Directorate. So in this box you can see Prevention of Money Laundering Act of 2002, Foreign Exchange Management Act of 1999, Fugitive Economic Offenders Act of 2018, Sponsoring Agency under the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act of 1974. So all these are generally related to the financial matters or the international crimes which are related to sponsoring to the illegal people or involving in the economic offenses. So all these cases are dealt by the ED. So here the ED chief and its members are appointed under the Central Vigilance Commission Act of 2021. So under this act the ED should not be more than 2 years, but the ED chief can be appointed for a third annual extension under the Central Vigilance Commission Act of 2021. But recently in 2021 Supreme Court has given judgment amending the Central Vigilance Commission Act 2021, Delhi Special Police Establishment Act 2021, and the Fundamental Rules 2021. So under this, the Supreme Court has upheld all these acts, and it said that the maximum term of the enforcement directorate should not extend 2 years, and as it influences politically, so to maintain accountability and transparency, the ED chief term should only be for 2 years. It should not be extended for the third time. So this was a judgment given by the Supreme Court. So under this, the Supreme Court upheld the third extension given to the ED chief as invalid. So this is about the news of ED. The next topic is Multi-State Cooperative Societies Amendment Bill 2023. So multi-state cooperative societies means the cooperative societies which are present in more than one state. Okay, so the previous act, we have previous act regarding the multi-state cooperative societies. So this time both the houses has passed the new bill of Multi-State Cooperative Societies Bill of 2022. Okay, so the previous act of Multi-State Cooperative Societies Act 2002 is amended, and a new Multi-State Cooperative Societies Bill is passed by both the houses of the Parliament. So as per the new act, the elections of the cooperative societies are held by the Cooperative Election Authority. Okay, the Cooperative Election Authority will conduct the elections of this multi-state cooperative societies. So this one you can see over here, Cooperative Election Authority will conduct the elections for this board, and this Cooperative Election Authority is established by the central government, and the Cooperative Election Authority consists of a chairperson, vice chairperson, and up to 3 members. So all these are also appointed by the central government upon the recommendations of the selection committee. And if any multi-state cooperative societies become inactive or they are under losses, then the multi-state cooperative societies which are under profit and earn more in a year, they should deposit at least 1 crore or at least 1% from their total annual profit. So it is like helping another multi-state cooperative societies. Okay, so for the dispute resolution under this multi-state cooperative society, the central government will also appoint an ombudsman system, cooperative ombudsman system. So under this, the problems for various multi-state cooperative societies can be solved, and under this act, the multi-state cooperative societies will have a maximum of 21 directors. Okay, and from this 21 directors, 1 should be from SC or ST member, and 2 members should be from women category, and if needed, the board also can appoint 2 additional directors. So this is about the multi-state cooperative societies topic. The next topic is Cinematograph Amendment Bill of 2023. So before we used to have Cinematograph Act of 1952, but now there are various issues which are becoming a challenge for the certification, film certification. So various several categories have been laid down by introducing this Cinematographic Amendment Bill of 2023. Okay, so this new bill actually amends the Cinematographic Act of 1952. So recently this new bill was passed. So under this new act, the certification of the films is done through the Central Board of Film Certification. Okay, so later, so if under this act, if this board CBFC gives a certification, and later on if there is serious rejection from the people, or which is posing several any problems, then this CBFC under this act can modify, delete, or the board may also refuse to exhibit the film under this new act. So the main objective of this new bill is to make the certification process more effective, and it also introduced many certification categories. So this is all about the Cinematographic Amendment Act of 2023. The next topic is right to silence. So under Article 20 Clause 3, all the individuals have the right to remain silent. Okay, but this article is only limited to the criminal proceedings only. So the Supreme Court said that investigators cannot be forced, the investigators like police officers and various several officers cannot force the accused to speak. Okay, so under this article 20 clause 3, and this is only valid to the criminal proceedings. So under the Customs Act of 1962 and Foreign Exchange Management Act of 1999, the right to remain silent is not applicable. Okay, so here the criminal proceedings are there within the country, and but the Customs Act of 1962 or Foreign Exchange Management Act of 1999, so all these are related to the international frauds or international crimes, all these things. So under this act, if the person is arrested, then the person cannot keep quiet. The investigators have the right to make the accused speak. Okay, so in these cases, when a person is arrested under these two cases, these two acts, then the person does not have Article 20 clause 3 with him. Okay, he doesn't have right to remain silent with him if he is arrested under these two cases, these two acts. Okay, so this is about the right to silence topic. The next topic is SOP to check the use of freebies, liquor to lure voters. So SOP means standard operating procedure. So the standard operating procedure will be laid down to check on the usage of freebies. What are the freebies? Freebies are the free distribution of anything, like free distribution of laptops, mobile phones, televisions by the politicians during the election process or before the election process in order to gain the votes from the people. Okay, so these are the freebies, and the freebies also can be referred as like free electricity and free vehicles. All these things come under the freebies only. Okay, so generally the freebies are like the instrument for the politicians to attract the voters. So actually this freebies is illegal, but it is done on the name of several schemes. So here SOP, that is the standard operating procedure, will be laid down to check on the usage of the freebies and liquor which attracts the voters. So SOP guidelines, that is standard operating procedure guidelines, are issued by the Central Board of Indirect Taxes and Customs. So SOP to check the freebies helps to prevent the freebies, smuggled goods, illegal trade of the liquor, drugs, narcotics, and it also counters the distribution of the black money. So these are all about the SOP rules. The next topic is demarcation of roles of MCA and MEIT. MCA is the Ministry of Corporate Affairs and MEIT is Ministry of Electronics and Information Technology. So demarcation here means making clear boundaries between both these ministries. Okay, so why there is a need to make the boundaries for MCA and Ministry of Corporate Affairs and Ministry of Electronics and Information Technology is we are transforming to a digital India. So there is a confusion between both the ministries regarding the acts and laws. So here the center has marked clear boundaries between the Ministry of Corporate Affairs and the Ministry of Electronics and Information Technology. So India is focusing on the digital market. So various legislations like Digital India Act, Digital Competition Law, etc. were laid down. So to avoid confusion between different ministries, Center has assigned all the digital market competition issues to the Ministry of Corporate Affairs. Okay, all the competition issues in the digital market were handed over to the Ministry of Corporate Affairs, and sector specific issues like service sector, infrastructure, etc. all these were assigned to the Ministry of Electronics and Information Technology. Okay, so the sector specific issues were handed over to the Ministry of Information and Technology, and the competition issues in the digital market were handed over to the Ministry of Corporate Affairs. So to avoid frequent overlapping of powers between these two ministries, demarcation of the roles of these two ministries were laid down by the center. The next topic is dark patterns. So dark patterns are used by the internet based companies to trick the users for agreeing certain conditions, and if we click any links in the shopping website or anything, we'll get frequent ads podcasted in our screen. So the dark patterns are also manipulated. These dark patterns manipulates the users and adds more amount to the product, hiding the actual price. So to counter these practices, the Advertising Standard Council of India, that is ASCI, the Advertising Standard Council of India, has issued the guidelines for the dark pattern. So it will be implemented from the 1st of September 2023.